that well, you know, if a little old lady got knocked down, everybody would be found guilty. But this isn't a case about getting a little old lady getting knocked down. And in that case, if there was some case like that, the judge would instruct the jury on what those elements are. And you're not to presume that somehow, because Mr. Riccardi says that's the case, that it is. You're listening to the instructions on this case, and that's what you're going to be instructed on. But the question is, and the question I want you to examine, and let me tell you something right now. I know that the easiest thing to do at this point is to say, you know what, he participated in it, this man is not alive today, too bad for you, Jonathan, too bad for you. And we're going back and find you guilty of murder, and that's all there is to it. That's the easiest thing to do, and I'm asking you to do more. We talked about jury duty from the beginning. It's a duty. It's not supposed to be easy. And for people that are listening to it or watching it or reading about it in the paper, they're entitled to say, that Jonathan Dukes ought to be found guilty of murder, and that's all I care about. But those of you that have accepted this duty have to listen to the instructions and listen to the evidence and make a decision, which is sometimes hard, but sometimes right and correct in this case. And so no matter what your emotion is, and I'm telling you, I feel it too, and you can't help it. And as Jonathan said, I didn't do anything to help the man. You know, we feel that, and I understand that tendency. I told you from the beginning, he told you, and he told you that when he gave that statement to Lieutenant Johnson, that Mr. Lowther did not deserve it. He said that twice. Mr. Lowther did not deserve it. And nothing he said and nothing I said is to suggest anything else. And that's why I'm saying the easy thing is just to say that it's murder. And as I said from the beginning, nothing that we say here indicates that Mr. Lowther did anything wrong. And even though I'm talking about that consent, and I'm going to talk about it some more, I'm not saying Mr. Lowther did anything wrong. He suffered, he was feloniously assaulted. He suffered a very, very hard and difficult injury. And the prosecution is free to charge, even though Mr. Dukes is not charged right now with felonious assault. They're free to charge him with that. But that's what it was. And when you look at the medicine, you really can't come to any other conclusion. And I'll tell you what. I'll tell you, the first thing that I don't understand, and I simply don't understand it, what was the rush? What was the rush to take him off the ventilator? When we look at these records, which we're going to do in a few minutes, when we look at these records, every record with regard to this consent screams practically, hold off a little bit. Hold off. Let's see. We do not know whether he will need to be on a ventilator, which was his major concern, that he will need to be on a ventilator. We do not know that. And yet, the doctor that wasn't his treating doctor that came in to talk to him about going off the ventilator says, to a reasonable degree of medical certainty, you're going to be on that ventilator the rest of your life. Now make your decision. That doctor who told him that, the day before knew that he was suffering from delirium and frustration at the acuteness of his injury. And I'm not going to spend too much time on that because I'm going to put what he actually said up there, and you don't have to rely on what I'm saying. It's not something that we're making up. But let me tell you a few things first. Dr. Dean, and you were told what Dr. Dean said. When I got up and I asked Dr. Dean wasn't asked about the removal from life support until I got up. And I said, Dr. Dean, isn't the immediate cause of his death the removal of him from ventilation? Yes. And isn't it a fact, Dr. Dean, that you don't have any idea how long he might have lived? And the reason for that is he could have lived many, many years. It's particularly true, and she agreed, there's no way to tell. It's particularly true when they're not sure yet that his breathing isn't going to improve so that he won't need it. And there's all kinds of indications in the record that that is what was happening. That's why it's a felonious assault. Again, I don't understand the rush. a 68-year-old man requiring a lot of medical attention. It may be that there is a reason among some hospital personnel to kind of rush that decision. And when we look at the actual facts, not what I say, not what Dr. Arden says, but what they say at City Hospital, I think you'll see exactly what I'm talking about. There are 3 exhibits, and I have all 3 of them here. And they show the treating doctor saying something completely different than the doctor that's talking to Mr. Lowther. Looking at Exhibit E. Right down here in the highlight.
Sidebar here. Those highlights are not from the original record.
Emphasize them.
The highlight is not
It's just
those are what's going back.
No. Just first. Close it. Open them. In fact, these don't even have the sticker on them. But this is an exact copy of Exhibit E. What does it say here? And right down where my finger is, within a reasonable degree of certainty, he will be permanently unable to sustain his own vital functions without mechanical assistance for breathing. And yet, the doctor that was treating him, and if you look through all of those records, the attending physician, the one that was coordinating and caring for his treatment throughout the process, says, he will probably require ventilation for some time, if not for the remainder of the life. That decision has not been made. The people that are treating, and you heard the examination, the cross-examination of Dr. Arden, well, isn't the treating physician in a better position to decide what the prognosis is? This treating physician, and you look at the date on this, on the second page, it shows the date it was dictated, right here where my finger is, August 1st. It was after Mr. Lowther had passed away. And even at that time, the treating physician knew that whether he was going to need to be on ventilation had not been decided. And he was the one. He was the one that would make that decision. He knew it. But nonetheless, Mr. Lowther is told, oh no, it's with a reasonable degree of medical certainty, you're permanent. Mr. Lowther did not consent knowingly. He did not consent knowing what the real diagnosis was.
There's no evidence of that.
This is the evidence. Okay, thank you, Your Honor. And again, you hear objections, and what we lawyers say, you've got to weigh that in. It's not evidence, but this is. And again, we're not the ones making it up. And you heard Dr. Arden say he looked at the record. There's nothing in the record that indicates that the need for ventilation was permanent. Nothing. Now, obviously, this is difficult, but you can look through these records, or you can look through the records that we've separated. There is nothing indicating that this is, to a reasonable degree of medical certainty, this is the case. He was not given the proper information. Let's look at what it says, again, right above that, in the same document, which is Exhibit E. Best interest, it's called. You can see where it says best interest. There is some concern from the best interest standpoint in light of the literature that suggests, now this isn't somebody saying, oh, the medical literature says, or this is the state of science. This is the doctor that is talking to Mr. Lowther, and this is supposed to be accurate, although he wasn't actually talking to him that day, but that was his understanding that he conveyed to him the next day, and you can see that on the one from the next day, which I'll show you in a minute. In light of the literature that suggests a number of paralysis patients change their mind, favoring continued life, when they're a little remote from the acute injury.